Good morning, Mr. Kharakoz. I wish to welcome you on behalf of the Selection Commission to the second stage of our selection process for candidates for the High Qualification Commission of Judges of Ukraine. That is the interview. I should firstly introduce the fellow members of the commission with whom you will be interviewed, or by whom you will be interviewed. And I have Mr. Robert Brookhuizen to my left, and to my right I have Judge Sergei Verlanov and Judge Stephen Markman. And we will be the interviewers. I will note for your information and that of our viewers that Justices Ivan Mischenko and Yevgen Mezentsev have recused themselves from this interview process because of an acquaintance with this applicant. I should tell you, Mr. Kharakoz, that we will conduct this interview, of course, remotely, and you are on our video monitors. If we should have any technology issues because of the current circumstances in Ukraine, we will recommence your interview, and our secretariat will get in touch with you should there be an interruption in the service to set a new time and new place for the interview, and we will continue the interview where we left off. I'm going to encourage you, sir, as we have done with all of the candidates, to give concise answers to any questions that you are asked. We want to ensure that all of the members of the Commission have a proper opportunity to ask you the questions that they have. In this particular interview, the lead reporters will be Mr. Brookhuizen and Mr. Verlanov. And with those introductory comments, I will turn you over to Mr. Brookhuizen, who is the first rapporteur. I should advise you that you have the opportunity, after he introduces you, to make a self-introduction and as well an opening statement, particularly with respect to your motivation for having applied for consideration by our Selection Commission. So, Mr. Brookhuizen, I will turn the candidate over to you, please.
Thank you, Mr. Zajecny. Good afternoon, Mr. Kharakoz. Well, as the chairman just explained, the idea is that you give a brief introduction, that you introduce yourself, explain to us and everyone who's viewing what you do, who you are, and why you are applying for this important position, and you have 5 minutes for that. Please go ahead.
Thank you. First of all, thank you for giving the floor to me. Thank you for the opportunity provided to me to participate in the selection. I'm Kostiantyn Kharakoz, and I represent the judicial community, which means that I'm a judge of a commercial court of the Donetsk region, and at the same time I'm a professional lawyer. I started actually this activity even from school, because I finished the school where my class was specializing, my group was specializing in law. And that was my free choice. I got my education in Donetsk National University, and now I study in the postgraduate studies department of Kharkiv Law Academy. It should be indicated that academic education has also pointed out to me the ways for development, for self-education, self-training, and that's why I do not limit myself to the formal program. I'm also interested in a lot of other issues, and I've been dealing with the concept of human rights development I'm very much interested in history of law, mediation, and other tools of dispute resolution. I'm also interested in history and systemic psychology, because without them, it's difficult to understand law and the legal system. As far as my professional activity is concerned, let me mention that I started it as a student, and I would split it into 3 parts, not to enumerate all my positions. So first, I worked with some companies where I got this experience of systemic, mutually binding work for the sake of achievement of certain objectives. This was within joint stock companies in particular. And the second part would be my private activity, like practicing law in 2012, on the basis of the results of the first open judicial selection. I started being a judge in one of the courts of Donetsk region. And then, on the basis of my application from this Varshilivsky district court, I was transferred to commercial court of Donetsk region. So that's like the last part of my activity. In 2018, I also undertook qualification assessment. I was a success. My mandate was validated, and since 2019, I've been a member of the Association of Development of Local Self-Governance, and in 2020, I was elected to the management board of this association, and my civil society activity also is represented through my involvement in the Pravo Justice project that deals with the reform of the judiciary, and which is particularly designed for Donetsk and Luhansk regions. I would like to focus on my own vision of the judicial reform and the reform of the state sector as such. I think that this is a picture we should always see in front of our eyes when we are working towards something. I think that we should focus on the classical definition on which our institutions are based, about independence and impartiality of the judicial branch of power. And this is all based on the model of democracy, where the main goal of the judiciary is to prevent arbitrary will, arbitration. And my vision concerning what the judiciary is also based on the Constitution, and judge is the carrier of the legal, of the judicial power, and that's why development and selection of judicial bodies is the task of the HQCJ. And the goal of the judiciary is to prevent any legal mistake from happening and to ensure independence and impartiality of judges. As far as the work of the HQCJ is concerned, let me give the framework for it. I think that the processes and the procedures of selection and qualification assessment aim at the development of the value-based community. This work aims to establish corporate culture which prevents corruption, which eradicates corruption from the judiciary. And I think that we have got all the chances to actually improve the judiciary. And when you ask me further questions, I will, I think, have a chance to give details.
Thank you, Mr. Kharakoz, for your explanations. And certainly, there are all kinds of subjects you touch upon that we will no doubt discuss during this interview. My first question to you is as follows. In your motivation letter, in point 1, you say, a long period of reform and hype accompanying it have brought the judicial system to the point of, I have to ask,
Bifurcation.
Bifurcation, sorry. A difficult word, bifurcation. This state is acutely felt by the society and consistently reflected in sociological surveys, which in turn creates public tension and becomes a pretext for political speculations. Yeah, when I read this, it is as if it is, let's say, the reforms by itself and the press reporting about it and the public finding something about it, the reason that all those reforms take place. And maybe it denies the fact that there is indeed a problem in the judiciary. Can you please explain what you meant with this paragraph and what you wanted to say to us when you wrote this?
Thank you. You know, probably I really have touched upon too many of my aspects, both in my speech, introductory speech, and the motivation letter. But this point of bifurcation or bifurcation comes from cybernetics, the science of systems. And when we speak about reform of the judiciary as a part of the social institution, we need to take into account the laws of cybernetics. And the point of bifurcation is the status in which the system can be changed, the point of change. I think that the reform is now on its wave. I mean, one more regular wave of the reform, and the reform is about to be completed. It is at the final stage. The reform started from the moment Ukraine gained independence, and it has several waves caused by some critical points, reached points of time that enabled us to build some system of relationship in the society that meets the characteristics of democracy. And in this specific respect, the point of the bifurcation shows that the traditional influences within the system cannot be performing their functions at the moment. And that is why, in that moment of time, at the point of bifurcation, the system can either be fully destroyed, collapse, or be reshaped. This is the law of cybernetics. If I could provide it some wide and more extensive explanation, I could, but this is the short answer.
Okay, but so I do understand correctly that did you mean that the judiciary is at the point of collapse, or did you mean to say that the judiciary is at the point of revival, or reinvention?
Well, this is one and the same point, actually, whether the system may either collapse or start being restored. There could be two ways. Total destruction in the context of the judicial reform, or there is full distrust in the judiciary among society representatives, in particular in the war times. This is possible. So this means that at this point we could go to the negative side or to the positive side, and it depends really on the effort that we now take. The direction of our further movement depends on that. And I think that it depends on us, what direction we choose now at this point of bifurcation. But this is one and the same point. The question is where we move.
Yeah, I think I agree with you about that. In the Netherlands, I've been speaking to quite a number of judges from Ukraine who received training by the courts in the Netherlands. And when I was discussing with judges, and I was having, let's say, I gave some speeches and we had discussions afterwards, what my experience was is that there's quite a lot of denial within the judiciary of Ukraine that a problem exists. Only often is referred to the fact that there are not sufficient judges. There's often no reference that there are, let's say, other systematic difficulties like corruption and lack of trust for whatever reason. How do you see this? Because if you do not recognize the question or accept that there is a problem, how would change be possible? If you think about yourself, it's all perfect, why would you change? And that's a bit of what I sense sometimes when I speak to judges of some position in Ukraine. A denial of a difficulty, of a problem.
So let me try to tackle this issue step by step. I think that we do have a systemic mistake. And this is the mistake resulting from the fact that our society is treated as a transitionary society when we are going over from totalitarian past to the democratic future. And systemic mistakes are naturally there. They are naturally in place. If we ask the general question about corruption, I would differentiate between some notions here, distinguished, but not notions, but definitions. I watched one of the interviews, and you asked this question. There is bribery. I mean, there is a separate definition of the notion bribery when there is a person who gives a bribe and the person who takes the bribe. And this is the crime which is qualified in the Code of Criminal Procedure, and we do have the anti-corruption vertical line. But there is also a different term, attribution, which is projected by the authorities on societal relationship. I mean, this could be closed procedures, the terms of doing business, and this is also something that leads to corruption. If we speak about staff shortage. Staff shortage is a problem which may create such perception even if there is no corruption. And let me give an example. Suppose there is a judge who can hear a certain number of cases. He needs to hear the case, he needs to study the materials in the case, so he is limited in terms of the number of cases. And within a year, he can hear, let's say 500 cases. But because of the staff shortage, we do have a situation when he has to hear about 2,000 cases a year. The judge doesn't have a secretary, he doesn't have an assistant judge, he doesn't have paper to print something out, and he doesn't have the marks for the envelope. A person goes to court and has got reasonable expectations to get a decision within a month, but he is never summoned to a court hearing. So this leads to the shortage of decisions not related to the very law. You know, I was born in the period of the Soviet Union. And then, in order to meet your basic needs, you were supposed to have some contacts. You couldn't even buy something in the shop. And what is the perception then? A person thinks that here is my my right under the law, but there is some person who doesn't give me this. What does the person do? Either the person puts up with this, that he has to wait, or tries to look for a person who can help him or her. Even to appoint a secretary for this court, for this judge. So this means that certain need of a person cannot be met in a legal, transparent way. This is not a general explanation, but I think it's a good example worth considering when probably, maybe there is corruption in this case, maybe there is no corruption. But anyway, there may be some wrong perception and maybe some external influence
I understand.
the person is seeking just to meet his legal need.
Yeah, of course I understand that if you do not have enough people to deliver justice and make sure that people get a judgment within due time on the issues that keep them apart, if you do not have enough prosecutors to prosecute criminals, if you don't have enough judges to sentence criminals, that's all very, very bad for the trust of the society in the judiciary. But the question, of course, is whether this is all and whether there is not more. And what I see from my position and what I've seen in this commission, I see many judges who have been able to acquire quite substantial wealth, and sometimes it cannot be fully explained where the wealth comes from. It seems always to come from grandmothers or from fathers-in-law or whatever. And it also seems that the judiciary, if I'm critical, and I am, and let's say I'm here in this commission because I am, that the judges sometimes act as if they have earned this wealth by just being a job which is essential for their society, I believe that other change is necessary. Is that also your view?
Well, my view of the situation is the one that I indicated in my motivation letter, in fact. Again, let's get back to the example I gave you. There is the notion of openness. The issue of corruption is a general one, but when we have openness and clarity of all the procedures, and when the expectations mentioned in the law are based on systemic conditions in which you can work properly and adequately, like proper funding, proper provision of staff, a good community, a good environment created for this. So these systemic factors will ensure a fully functioning system. This system itself is a litmus that will show whether there are problems or no in the system. But if we speak about the tools through which this could be achieved, it seems to me that they are obvious. You need to have proper communication with people, and you should have open, clear, transparent procedures. You should do some awareness raising campaigns, and this culture of relationship, new culture of relationship, should be built. And I don't think that we can ever influence the past. No way. But we can be fighting the stereotypes, showing that you cannot get something if just by way of resorting to some indecent practices.
Maybe I understood you wrong, but if I listen to you, what you say is that, in fact, the problem I just touched on does not really exist. It's a question of better communication and better performance of the judiciary by delivering the judgments of quality and in time. Is that what you say?
Well, probably I've really phrased myself not in the best way possible. I don't actually doubt what you say, and I don't actually doubt that whether I see it or no. I mean, in my environment, I don't see this, but every alien observer can be more objective about the situation, as, for example, you can. Of course, corruption does exist to a smaller or a higher degree, but the problem is that probably it is the task of law enforcement bodies and specialized anti-corruption entities to be looking for the people who are the cause of corruption, who are to be blamed for this. Within the legal system, within the judiciary, we cannot do this. And again, getting back to the example I gave, if a judge cannot hear a case because of such shortage for a long period of time, and he cannot ensure even some physical consistency, physical sequence. Like he just takes a case, here's this case as the first one, and the criteria why this was the first case to be considered and heard by him are not known. That will create the impression that he has some corrupt practice. I'm not denying the fact of corruption. I'm talking just about the systemic grounds that give birth to such opportunities for informal practices.
Okay. We do understand each other now, I think. I will pass the floor to my dear colleague Sergej Verlanov, Sergej, who's the co-rapporteur.
Thank you, Robert. Good afternoon, Konstantin. Let's speak on some issues related to your professional activity, and let's speak about your participation in the judicial self-government bodies. As we can see from the materials in the case that have been collected by the Commission in relation to you on the 13th of September 2016, you and two other judges, your colleagues, from the Commercial Court of Donetsk region addressed the High Council of Justice with an application that there is some interference into your activity. In particular, there were some publications in mass media concerning non-impartiality of judges during the case involving some religious organizations, if you remember about this case. Later, the High Council of Justice, with its decision of the 13th of August 2019, did not find any grounds to respond to your application. Could you comment upon this situation? In brief. Yes, sure, I can comment upon this situation. We were considering a case, 3 judges were doing this, and there were publications in mass media, and there were some people attending the courtroom, about 15 or 20 people. They were rather aggressive, and even during the court hearing, some threats were voiced. They could be heard in the courtroom. I would not tell what exactly these threats were about, but it definitely went beyond the limits of proper human communication. These were vulgar, taboo words, and there were some claims that we were from Donetsk. I was from Donetsk by origin. The point is that Donetsk Commercial Court is now located in the city of Kharkiv. We were relocated, and that's why they were shouting that we are from Donetsk and we are not fair. That's why we wrote their application to the High Council of Justice, because we thought that this was pressure exerted on us. They were trying to make us read the decision which was in their favor. But the High Council of Justice really didn't find the grounds to respond. The materials were transferred to the investigative body. And about a year and a half after that, one of the inspectors from Kharkiv police came up to us and said, well, you wouldn't insist on our considering this case, right? This application, right? So actually no proceedings were initiated by the law enforcement bodies, and there was no procedural decision about this, right? Right, yeah. There was no procedural decision. Okay, thank you for your answer. Here is my next question to you. We can also see from your materials that you were elected a member of the NGO, Association of Development of Judicial Self-Governance, in 2019, and in 2020 you were elected a member of the board of this NGO. So the materials show that in September 2020, on the basis of the decision of this board, of this organization, there was a publication made that was actually the application entitled The Principle of Judicial Reform, and it said that the civil society organization involved in the reform of the judiciary may have an advisory role, but their decisions cannot be binding for state authorities and local and judicial self-government bodies. And you also disagreed to involvement of independent international experts. These statements actually evoked some criticism of civil society organizations, and that's why I would like to clarify it with you. What is your current attitude to applying for the HQCJ? You have applied to this selection commission, which actually has 3 international members. So I would like to ask you about this. Thank you for the question. Using this occasion, I would give the answer not just to my general attitude, but will also provide the interpretation of this application, of this statement. Well, concerning my personal attitude, taking into account the current reality, anyway, the decision on my candidacy will be passed by international experts as well. I'm really respectful about their involvement. I think that these materials are available in the judicial dossier of mine, because you can see from those materials that I also applied for the High Qualification Commission of Judges under the requirements of the previous law of 2019. This competition, the selection did not take place because the Constitutional Court of Ukraine decided that the selection would not be illegal because of the grounds mentioned in the statement which you quoted. So I think that this illustrates my attitude to the participation of international experts in this selection. Then concerning the statement, I think that the attitude of the civil society organizations points to a sudden communication error, communication failure. If we speak about the relationship between legal authorities, state authorities, and civil society. Judicial associations were signing this statement, and I will not say that I had nothing to do with this application, with the statement, that I was not involved in the process. I really was one of the members of the management board which discussed the statement, and I voted in favor of it. I voted for it, and I will explain why. The statement really said that formally involvement of international experts violates the sovereignty of Ukraine, but that was actually the application to the state authorities, and this was the statement of the self-government, judicial self-government. It was related not to the reform in general, but to certain characteristics and signs of the reform only. And I think that these elements duplicate the reservations expressed in the decision of the Constitutional Court, which acknowledged the previous law to be unconstitutional, and it also contains references to the comments made by the Verkhovna Rada of Ukraine and their consultative body. And by the way, you can get acquainted with those comments on the website of the Verkhovna Rada of Ukraine. These documents are in open access. There are a lot of remarks and comments there. For example, this expert and consultative bureau mentioned that only judges could actually participate in this process, but we disagreed with this. And this is just the issue of constitutionality. I'm not a constitutional lawyer. I'm just a professional lawyer. I have the understanding of the basic principles of the Constitution, of course, and I think that they exist to restrain politicians from crossing red lines. And for me, voting for this statement was preceded by the fact that there was no public discussion, no public dialogue on that matter, on the issues that are obvious for lawyers. There was no public discussion at all. That's why we made this statement, because it was supposed to start a certain dialogue. Okay, your arguments are clear. Thank you, Mykola. Thank you, Kostiantyn. And here is another question to you. Please provide us with some information. We can see from your materials that you visited the Crimea in the summer of 2014. And the territory was already occupied. This is just fact. So here comes a logical question to you. Do you have any relationship, either you or your relatives, do you have any relationship with anybody or anything in the territory of the temporarily occupied part of Ukraine or Russian Federation in general? Yes, thank you for the question. Let me give the answers to the questions, because these questions are something not just the Commission is interested in. It's well, actually logical from the current situation when the country has been at a full-scale war for about a year. It's absolutely logical to ask the question about the territories invaded by the aggressor state. I have just one passport, one citizenship, and I never tried to exchange it for some other passports. I love my country. And as far as the visit of the occupied territory is concerned, which was non-government controlled, not only of the Crimea, I also went to Donetsk, which was also under occupation. I provide the explanations, written explanations to the Commission. But for you to understand my explanations, so I'd like to go a little bit deeper, not just into the context of 2023, when we have missile strikes and when people are dying, but in the context of 2014, where we were in the status of uncertainty, in particular by we, I mean a person who left Donetsk. I gave the reference to mass media publications which showed some attitude, specific attitude to people from Donetsk. And unfortunately, the state authorities have recognized the Russian Federation to be the aggressor state. In relation to the Crimea, it was determined almost right away, but in relation to Donetsk and Luhansk regions, it was not determined for a long period of time. And for quite a long period of time, the war going on was actually called the anti-terrorist operation. We are always looking for somebody to blame. And the society thought that people from Donetsk are to blame. And in the summer of 2014, I went to the Crimea because I already had the trip voucher, which I already had paid for. And somehow I could not rent a car in that moment in any of the regions, like Dnipropetrovsk regions or any other regions. I just needed to have a place to stay in to get clear about where I go next. I stayed in the Crimea for about a week or two, I don't remember exactly, and then I left the occupied Crimea. I didn't even stay till the end. And this was, by the way, the trip voucher which I had bought in 2013. So then I went back when their management, administration of the judiciary got clear about the fact where Donetsk, a commercial court, will be located. I'm sorry, I have to interrupt you because you are rather extensive. You have informed that you have been there for a week or two. You came back because it was already clear where the commercial court of the Donetsk region will be located, and then you didn't go there anymore. I have some regular relationship with the territories which are my, so to say, small motherland. And I don't think that this is any pressure. This is just emotional connection because I still feel willing to get back there with the Ukrainian flag. But that's it. Okay, thank you. And then let me give the floor to Judge Markman. Stephen, you're welcome.
Thank you, Judge Verlinoff. And thank you, Judge Kharakoz, for your participation in our competition. I think that my colleague, Judge Verlinoff, has asked several very important questions, and I hope you wouldn't mind if I follow up briefly on those two questions. Concerning the Crimean visit, I've seen your explanation, and it is that you had a travel tour from 2013, and that would have obviously been financially burdensome to lose whatever investment you had there. But in retrospect, do you think that you can understand why some Ukrainians may not have looked very approvingly upon that visit still?
Thank you. That would be a reasonable question that Ukrainians or some Ukrainians may have. It's logical to ask what my connection to the aggressor is. Maybe in retrospect, looking back on the situation of the summer of 2014 with the eyes and knowledge that I currently have, I would probably not have gone there. But at that very moment, I was just trying to find a place where I could stay. It wasn't about having a vacation because I have already paid for accommodation. And it was difficult for me as a person with Donetsk registration to find any kind of accommodation on the territory where the hostilities took place. And also in my explanations, I have provided you some of the examples about the situation at the time.
Okay, thank you, Judge. Concerning the other question that Judge Verlanov asked about the actions of the Association for the Development of Judicial Self-Government of Ukraine, I've seen statements from some civil society organizations, for example, the Corruption Combat Center, which has interpreted that statement as disparaging and diminishing the role of civil society organizations in Ukraine. And I don't know whether you agree with that characterization or not, but I've seen it understood that way, not so much the involvement of internationals. We understand reasonable people can certainly differ on the question of international involvement, but principally on the role of civil society organizations in Ukrainian judicial reform efforts. What is your response to those civil society organizations that have looked at those statements and seen it, and I put it in their words, as evidence of opposition to judicial reform? You would not agree with that entirely, I suppose. Is that correct?
Yes, I would disagree with this kind of statement, but I agree that the civil society organizations may have this opinion. That's number one. And number two, about the involvement of civil society organizations and the existence of civil society organizations, both anti-corruption civil society organizations and legal civil society organizations. That's a dogma, that's a fact. And the involvement of all of the stakeholders in the reforms of the judiciary, in the implementation of this reform, is logical and reasonable. And I don't think that is something that should be discussed even. But with regards to my personal view, I think that the result of the judiciary reform. Can you please tell me if you can hear me?
We can hear you very well. Thank you.
So this reform is about the change in the paradigm between the interaction of the judiciary and the civil society. There shouldn't be any confrontation when we are talking about the judiciary reform. And civil activists are primarily interested in having new standards of justice, because the reform will have a positive significance for the country. It's not about destruction. That's why I don't think it's something that we should be discussing. I think that the problem that we are having is lack of dialogue.
Thank you, Judge Kharakoz. The reason I want to ask you another question on that subject is because this has been a difficult decision-making process. I think all 6 members of this commission see these reforms as being extraordinarily important, and we know that many Ukrainians see it as being extraordinarily important. And in interviewing and selecting people, we can't make too many mistakes on on the question of integrity, the question my colleague Mr. Burkhuizen raised earlier. And I think also we can't make too many mistakes on the question of commitment to judicial reform. And I ask you this, I understand your statement in explaining what the association did and said, and it's to your credit that you accept responsibility for its statement and are explaining it. But this is my question. Beyond the words of your motivation, what evidence, what actions would you, Judge Konstantin Kharakoz, point to in defense of your commitment to judicial reform? What is the evidence that you would bring a deep sense of judicial reform if you were placed upon the High Qualifications Commission? I ask that not to be difficult with you or aggressive with you, but simply because it's so critical to the success of our commission, and we believe to the success of your country, that we place upon that commission people who are truly and sincerely committed to judicial reform. Everyone's motivation speaks about transparency and support for judicial reform, but it's nice to have actions and evidence, too, in support of that. Can I ask you if you might share your thoughts on that?
I think that the question that you are asking I can tell you a little bit about my activities as a member of the Association for the Judicial Self-Governance Development in Ukraine and maybe some other activities, but there is this statement that is being discussed that during the war, our society should not have this dichotomy between security and fairness. They are not mutually exclusive. And as part of the work of the association, I can provide you the examples of us having some educational projects which promote the very idea of justice, explaining the principles upon which justice operates. So this is the activity that the association was engaged in prior to me joining it. I'm involved in different educational events trying to convey the idea of justice to regular citizens and to my colleagues, to explain what the principles of the judiciary are. So I was involved in a number of projects. I was interacting with different organizations, again, within different educational events. We organized such educational events related to the judiciary. At the moment, the association is involved in the coalition of civil society organizations that document war crimes to help the law enforcement bodies. So they are compiling the catalogs. At the moment, we are completing our study on the needs of the national judiciary. So if you tell me that if I become an HQCJ member tomorrow and that must result in some kind of miracle, then I will disappoint you. I think the reform is not about the things that are done on the outside. It's also about changing the perception of people, meeting their expectations. I think that the question of trust and this inconsistency in the general level of trust and trust in the judiciary. So let us have a look at the year 2014. What has changed since then? If you are asking me for any kind of evidence, then you need to look at my actions. You can go to social media, you can go to mass media, which reported on what I have done in this respect.
Well, let me put the question just slightly differently. If any member of our commission was to speak to a leader of a civil society organization and say that Judge Kharakoz will be one of the people that we would like to place on the High Qualifications Commission, they would say, but he joined this statement of the association a number of years ago, and we think that that statement was hostile to civil society. And any one of us would respond and say to that civil society leader, we understand you disagree with that, but he explained his thinking on that. And furthermore, he has this evidence in support of a judicial reform. I'm still having just a little confusion in my mind understanding what that other evidence would be that I could share with them or my colleagues could share with somebody to communicate that Judge Kharakoz is a man committed to the kind of judicial reform that so many in your country would like to see.
Stephen, if you're asking me about evidence, I think evidence is crucial here. When we are talking about civil society or civil activists, it's kind of a general phrase, but this is a community consisting of versatile people. I support the reforms. I keep in touch with people. I meet people at different events. We have coffee with them. During coffee breaks, we speak the same language, basically. We prepare some joint documents, joint statements. Yes, there is no public dialogue, but we have communication on the inside. There are those organizations that criticize, and there are those that cooperate. So this organization, which I previously mentioned, Ukraina P'ята ранку, so we are discussing the restoration of Ukraine after our victory in this war. We are discussing the issues of the judiciary. I will now be mentioning specific organizations. With the juror, for instance, we have this very nice dialogue. If you're asking me about my personal stance, if I'm not mistaken, in September, I published a paper in which I expressed my view of the reform of the judiciary. And this paper is called The Psychology of Judicial Justice. It was not published in a judicial journal. It was more of a publicist-style article, which was later reposted to the website of one of the papers. The difference in opinions, the difference of lenses through which we are looking at the situation does not prevent us from communicating. I cannot prove apparent things. So we can listen and hear the opinion of others, and I think that I'm the person capable to do that. Thank you.
Judge, is that article that you mentioned about psychology, is that available on the internet, or is that something you have shared with us or could share with us? I haven't seen that myself. Is that available? Is that publicly available?
Yes, it's publicly available. It's actually available only on the internet. So the civil society organizations reposted that article. I can send you the article. I can send you the link.
Could you please do that?
Yes, so it's in public access.
All we need is the link, of course. Thank you. Let me ask you one final question, please, Judge. Is it true that you live with your wife, your daughter, and your mother at an apartment in Kharkiv, and the owner of that apartment is the Economic Court of the Donetsk region? And if that is accurate, can you just explain the circumstances? Maybe I don't understand the details of this kind of situation, but is that considered to be a typical housing arrangement?
Stephen, I need to give you further context because there may be different situations with accommodation. I'm an IDP, as many of my colleagues are, as many of my colleagues from the commercial court of the Donetsk region. So we are actually refugees, but we are IDPs because we left Donetsk, we left our apartments behind, and our court has been relocated to the city of Kharkiv. In general, we have this practice when local self-government bodies provide accommodation to judges that work within their community. It's called a corporate apartment. So this apartment has the same kind of status. I got this apartment not following the existing procedure specified by the Housing Code of Ukraine. In 2015, me and other judges during the Congress of Judges of Ukraine approved the decision under which the State Judicial Administration of Ukraine was supposed to provide accommodation for judges who left the temporarily occupied territories and relocated to the territories controlled by the Ukrainian government. Since we are a specialized court, we also have trial courts. So it's either the State Judicial Administration or some other judicial institutions that had to acquire that accommodation for judges. So I was given that apartment along with other judges from my court. So it's a corporate apartment. It belongs to the state. If you are asking me about my family, the composition of my family has changed, so.
No, you've answered my question. Presumably, you would continue living in that property for as long as the occupation took place. And do I understand correctly that you do not pay rent for that property?
No, I don't pay rent.
Okay. Well, thank you very much, Judge. Let me pass you on to my colleague who is chairing these proceedings, Judge Zarzeczny.
Judge Kharakoz, there has been a considerable discussion that you have been engaged in with my colleagues, dealing with issues largely of principles that impact on the judiciary and your personal views on some of the issues that are raised in the context of encouraging public trust and confidence in the judiciary. I want to move away from that for the time being and talk about meat and potatoes issues that we know the High Qualification Commission for Judges will be facing when it is reconstituted. You are well aware, I'm sure, of the huge number of vacancies. You are well aware in the judiciary. You are well aware of the need to requalify a very large number of judges who are waiting for requalification. There are retirements that need to be addressed. There are vacancies in the courts of appeal, which the law mandates have a certain quota. So there's a huge amount of work to be done. And I would be interested in having you share with us some of your ideas as to how this work can proceed and be done as effectively as human beings, dedicated workers can do, and what your views are about the approach that you would encourage your colleagues, if you are appointed, to take.
Thank you for the question. It's a very good one. So I've watched a number of interviews conducted by the Selection Commission, and I agree with those candidates who mentioned the use of some modern technologies, the use of mathematical principles, not some calculus, but the theory of probability. As far as procedural aspects are concerned, if I look at my personal experience of qualification assessment and the experience of my colleagues, I would introduce the experience of having questions asked prior to the interview, because very often the judges didn't know about the questions that they would be asked during the interviews. So with regards to some organizational issues, when we had that crack in the procedure for the assessment, when there was the tension between PIC and HQCJ with regards to the timeline of submitting the documents by PIC, I think that this issue must be discussed, and we need to look for a mutually beneficial scheme under which both the HQCJ and PIC can perform their functions. As far as procedural matters are concerned, we have this cornerstone, the identification of what integrity is. So that is something that is assessed by HQCJ, but unfortunately the decisions made by previous HQCJ were not always motivated, and for that very reason they were cancelled. That's why I think that the HQCJ must implement the practice of well-reasoned decisions. I think that integrity is not something that is black and white. It can be measured using some mathematical tools. And I think it's a question that must be considered by the Commission, because a decision that is not well-reasoned may be seen as a sign of abuse, and it's not a good look for the society. And the main thing when we are talking about the principle of political neutrality, I think that the HQCJ must become a professional body which is not influenced by some political slogans, as the previous HQCJ for some reason was a prisoner of those slogans.
Thank you. Let me just pursue some issues that you raise in your answer. I do not recall, before you have now suggested this, that anyone else has suggested that you can measure integrity by mathematical tools. That is a concept that I have not previously heard. Can you just explain what you mean by that? How can integrity be measured by mathematical tools?
According to the regulations of HQCJ and its methodology, integrity is not black and white. Integrity must be assessed. it must be measured in a way, the level of integrity. And quite often the Commission has asked these questions, and the chair, Mr. Mishchenko, has asked this question of what integrity is. I would like to share my vision of integrity. So if we look at the information put up on your website, I think that we can supply it somehow. If we are talking about the context of the judicial reform and the assessment of a particular candidate, it may be difficult to now interpret what I'm going to say, but I think that integrity can be measured just like IQ is measured, just like professional competence is measured and assessed. It's the desire of a person to reach societal benefits and to restrain their personal desires. So let me provide an example. You can find it in my motivational letter even. So it's about the violation of traffic regulations. So I'm suggesting 3 levels. So level 1 is you not finding yourselves in situation when you have to choose between public and private interest. Level 2, if you happen to find yourself in this situation, you must choose the public interest. And level 3 is when you decide to acknowledge your guilt. So if we have this dilemma and a person makes all the right decisions, then it may be the criteria for integrity. If we review all of the anti-corruption laws, this comparison between the public and private interest is the very core of corruption as a phenomenon. So if we apply the Bangalore principles, if we follow the norms of the Code of Judicial Conduct, if we create a catalog of these cases and examples, we will create this model of behavior which will allow for judges not to balance on the border, but to create this corporate integrity.
All of that was very interesting, but I don't think it answered the question. Your statement was you can measure integrity by mathematical tools. And I don't understand what concept you're promoting here.
Well, probably I didn't express myself well enough. By mathematical means, I mean that we can somehow assign figures, points for certain criteria. And if we take 300, the Commission has during the qualification assessment, so we can divide these points. For example, if a person never gets into the situation when there may be some signs of integrity, that is 300 points. But when the person gets into a sort of situation, but he or she gets into it and still has some means to settle the situation, the person gets lower score. If the person gets into the situation, it also matters whether the person is able to recognize the problem and make conclusions, learn some lessons, and avoid it in the future. This will be a different score. So I think that this is a topic for further discussion.
Yes, I think I understand it a little better now. What you're really talking about is the assessment of criteria of integrity by the allocation of points in a general scoring scheme for the assessment of a candidate. All right. But my question to you was intended to invite you to discuss how the very large workload that is facing the HQCJ would be handled. What priorities you would have for the HQCJ work, and how are there any changes that you would make to the process of the HQCJ in these extraordinary circumstances, which no HQCJ has previously faced?
I think that your question actually embraces several questions, the first of which is the load, the scope. And really, this scope calls for a very high level of dedication. There are some things that HQCJ can do now. There are some things that should be postponed because of procedural issues, and there are some processes that should be taking place in the current circumstances. First of all, there is the issue of appointment of the PIC, because we need to create conditions for this council to be established. And the second issue is establishment of the secretariat, because secretariat is the auxiliary body that will help the HQCJ in its work. The other question is about the priority of tasks, and I would split all the tasks into several parts. The first part of the task deals with the heritage of the previous composition of the HQCJ. I mean, the judges appointed for a 5-year term who have not passed the qualification assessment and who are now not able to administer justice. I think that the materials are already available. There are a lot of materials on those judges, and this is the priority task for the HQCJ. And while performing this task, the HQCJ will be able to somehow prove that it has started functioning. The other one is about qualification procedures and criteria. I would, for example, expand the range of criteria, and I would actually ensure additional selection, because something has changed and the conditions in the country have changed. And the third block deals with the general development of the judicial staff. So besides formal documents, that is also about negotiations with the National School of Judges, because the HQCJ will determine the timeline and actually reduce the timeline for the training of the judicial candidates who pass the selection. But the most important thing I would start with is not these measures. When you enter the building, the premises of the HQCJ, and actually before the HQCJ's new composition will enter those premises, they should probably go to the dining room where in that premises where the candidates are staying, while waiting when they are called for their interview. I think that you can feel the spirit of the candidates there. You should feel the atmosphere. So I think that the new composition of the HQCJ should determine what its mission is, what the values are, and to make a public declaration to the society, because election to the HQCJ does not presuppose an oath, but they should predetermine the priorities they will be guided by while doing their activity. Thank you.
All right, thank you, Judge Kharakoz. Colleagues, are there any further or other questions that you have of this candidate?
No.
We give the opportunity, Judge Kharakoz, to our candidates to provide a wrap-up or final statement. In other words, we give candidates the chance to have the final word. And so, as your interview is nearing an end, we are at that point where I'm going to invite you to tell us anything additional that you think that we should know about your motivation or otherwise your qualification for selection as a member of the HQCJ. The floor is yours.
Thank you. Thank you for the interview. Thank you for the atmosphere of a dialogue. And thank you for the atmosphere the selection commission and generally creating, because it inspires us and shows us that the judicial reform will be completed soon. I think that it's realistic to complete this judicial reform in the recent future. My personal motivation is my personal striving as a lawyer, a person who has dedicated all his life to the legal profession, is regardless of whether I'm in the judge's robe or whether I do something for business or I am a practicing lawyer. So independent standards of the court and respect for the court are something that open up new opportunities. That is also motivation for me as for the father who wants the conscious choice of the child to live during the wartime in Ukraine would be justified. This is a good motivation for me as for the person who lived the major part of his life in Donetsk. And this is my personal motivation, and there are a lot of questions I would like to be able to answer, to ask in court the people who are brought to account. For me, this is also the motivation to try myself, to try my hand, and not to be staying aside the process of doing the things that seem to be obvious. You just need to be honest. You need to call different events their own names. You should not be hiding behind your own private interests or some traditional cliches or some traditional people, reputable people who just don't want any changes to happen. For me, the reform of the judiciary and its content lies not in destroying the institution of judges, but that is all about our fight in Ukraine with the most important enemy of ours, which is not actually Russia, but our totalitarian past. And we've got all the chances to build a new future and to destroy that totalitarian past. So it's not about just judges, courts, and the society, but all state institutions, because that is all about being grateful to the people who are now defending our country and our independence and sovereignty with weapons in their arms. And this is the matter of justice and the matter of law. Thanks again for the interview. Really, probably, I didn't have a chance to tell everything, but we would need much more time for that. But anyway, thank you very much for the interview.
And thank you, Judge Kharakoz, for your application to our commission. That ends this interview, and we thank you for your participation.